Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to the fourth lecture of our course on law of copyright, patent, trademark and other IP. So far in first three lectures what we have understood, we have discussed the international documents related to intellectual property, mainly copyright, trademark and patent. And then we started talking about copyright law. I said initial few lectures will be on copyright, followed by a few lectures on patent and then trademark, and towards the end we'll have some discussion on other forms of IPR. We said the first thing is identification of subject matter. We discussed section 13. We said the list of subject matter is contained in 13. The protection is given to works, literary, artistic, dramatic, musical works which have to be original. Then we said cinematograph film is also the subject matter and sound recording is also the subject matter. In the third lecture, we discussed the meaning of copyright and we said that different subject matter will have different set of rights, and therefore we concluded that meaning of copyright is different for different subject matter. Now, once we understand the subject matter, once we understand the rights, the next obvious question is to identify the person who will own those rights. Who will own the rights? Therefore, the present lecture is on ownership first of all, and then we will talk about transfer of copyright. So, these are the two issues which I propose to discuss in next 50-55 minutes. To understand ownership, we will have to first of all understand who is the author. Author is the first owner. We will discuss in section 17. Author is the first owner of copyright. So, who is the owner of copyright? First of all, we will have to understand who is the author. Section 2D of the Act defines authors. It actually does not define, it only identifies who is author in relation to different subject matter. For literary work, author is the author. For dramatic work, author is the author. For artistic work, artist is the author. For musical work, composer is the author. For sound recording, producer is the author. For cinematograph film, producer is the author. And we have a clause, section 2D6, which says for any work which is computer generated, in relation to those works, the person who causes it to happen is the author. So, this is what you have in section 2D. You do not have a definition, you have the list as to who is the author in relation to different subject matter which I just mentioned. Now, how to define it? Author may be defined as a person who creates the work. And let me tell you, author is an artificial construct, because in section 2D, as I mentioned, in all the cases I am not referring to a natural person. For example, in 2D5 we said that in relation to cinematograph film, producer is the author. Now, producer is not a natural person in all the cases, because there are certain companies, production houses which produce films, and in that case that production house becomes the author. So, it is not that in all cases only a natural person is going to be an author. For phonogram, for cinematograph film, even artificial person can also be an author. Therefore, I said author is an artificial construct, it is a legal fiction. Why do we create this legal fiction? In order to find out somebody who will ultimately own the rights. Because I said in case of sound recording and cinematograph film, author is not the person who is creating the cinema, author is the person who is making arrangement for getting the cinema created. In relation to literary, dramatic, artistic works, author is the person, as I said, who creates the work. But when can we say that the person has created the work? A person has created the work if he is contributing towards the originality of that work. So, if I am changing the language of a literary work, I can be the author. So, author is the person who creates the work, means author is the person who contributes towards the originality of the work. And therefore, we can conclude that more specific is your contribution, better are your chances to be called as an author. As I already mentioned in relation to entrepreneurial works, cinema and sound recording, there is nobody who is adding originality, because as we discussed in section 13, going by the language of statute, originality is not a requirement in cinema and sound recording, because these are not considered as original works. So nobody can add to the originality, nobody can contribute towards the originality. So therefore, author is not the person who is contributing towards originality. In case of entrepreneurial works, section 2UU defines the term producer. It says producer is the person who initiates or takes responsibility of getting things done. So he is not creating, he is initiating the process of getting the film made. He is taking the responsibility of getting the film made. Similarly, in relation to section 2D6, I mentioned author of a computer generated work is the person who causes the work to happen. And there may be a big discussion possible on this point in relation to all the works which are created by AI these days. If there is a work which is created by artificial intelligence, it is always a debatable question as to who shall be considered as author of that work, who shall be considered as owner of that work. I will not go in detail of this part. The second concept is work of joint authorship. Section 2Z of the Act defines work of joint authorship. There are three requirements for a work to be called as a work of joint authorship. First, you have two or more than two authors who are contributing towards the originality of the work. Second point, the work is the result of collaboration between the authors. That means there is a common design. All the authors wanted to create the same thing. And third, the contributions of authors must merge in a whole. So the contributions of different authors must not be distinct. If these three requirements are satisfied, the work may be called as work of joint authorship. In the year 1937, a case was decided in England called as Donogh versus Allied Newspapers Limited. In Donogh versus Allied Newspapers, Donogh, who was a racer, was describing his racing experiences, and Felsteed, a journalist, was noting down those experiences in bullet forms. He did not know shorthand. Once sufficient material would be connected, he will go back, prepare the article, show it to Donogh. Donogh will make few changes here and there, and the article will be published. The question was, who is the author of these articles, Donogh or Felsteed? Donogh claimed that all the experiences which he shared with Felsteed belonged to him, therefore he should be considered as the sole author. Felsteed says the language belongs to him. He did not note every single word which Donogh mentioned. So therefore the language belongs to Felsteed, and thus Felsteed is the sole author. There can be a third argument that it's a work of joint authorship. But the court in the case of Donogh versus Allied Newspaper concluded that the language belongs to Felsteed because Felsteed did not know shorthand. He took notes in bullets, prepared the article, showed it to Donogh. Donogh made few changes here and there. We don't know what kind of changes did Donogh made. Did he make changes in language or not, was not clear. And in the absence of any clear evidence as regards contribution made by Donogh towards originality of the language, it is safe to conclude that Felsteed is the sole author of the work. So that is how Donogh versus Allied Newspaper was decided. Why I am referring to this case? Because I will be using it in another case decided by Delhi High Court in the year 1989. The case is called Najma Heptullah versus Messrs. Orient Longman Limited. It was a case related to autobiography of Maulana Abul Kalam Azad. The name of that book is India Wins Freedom. Azad was not in a position to write because he said, I am too old to write. Professor Humayun Kabir assured him that he will do the job of writing, and Maulana has to narrate his experiences only. The situation is quite similar to what I just mentioned in Donogh versus Allied Newspaper. Now Maulana used to narrate his experiences in Urdu, and Professor Humayun Kabir used to take copious notes. He did not know shorthand, obviously. When sufficient material would be connected, he will go back, prepare the chapter, show it to Maulana Azad, who will make changes. Many alterations, deletions, changes were done. Finally, the book was ready. Maulana requested Professor Kabir to remove some 30 pages from the book, which may be included in the second edition after 30 years. They agreed to it. Finally, the book was published. By the time book could be published, Maulana Azad passed away. Therefore, Humayun Kabir signed the agreement, publication agreement with Messrs. Orient Longman. In the place of name of author, you have the name of Professor Humayun Kabir. After 30 years, when publisher wanted to publish a new edition including those 30 pages, a dispute arose between legal heirs of Maulana Azad and Humayun Kabir as to whether the book belongs to Azad or book belongs to Kabir, or whether it is a work of joint authorship. Now, in this case, Delhi High Court comes to the conclusion that it's a work of joint authorship. The only evidence we had was the preface written by Humayun Kabir, in which he narrated that Maulana used to narrate the experiences in Urdu and I used to write it in language. It was difficult for me to reflect with full accuracy the opinions and thoughts of somebody else. So he is narrating the circumstances under which it was all done. Court concludes that the work is the result of collaboration of two authors, Azad and Kabir. So therefore it is a work of joint authorship. But what court did not examine here in this case is the extent of contribution made by both the authors. I will refer to section 55(2). Section 55(2) of the Copyright Act says, unless contrary is proved, the person whose name is there in the place of author shall be presumed to be the author. So if there is a book on which at the place where name of author is to be written, we have the name of Humayun Kabir, then there will be a presumption that Humayun Kabir is the sole author, according to section 55(2). And this presumption can be rebutted only when the contrary is proved. And in order to prove the contrary, we will have to prove 3 points: contribution by the authors, collaboration and merger. Delhi High Court decides the case on the basis of collaboration and merger, but did not inquire the extent of contribution made by both the authors towards originality. One may argue that it is based on incomplete inquiry. But the final judgment of Delhi High Court was that the book in question is a work of joint authorship, although it is, one may argue that it is not clear whether there is a clear proof of contribution towards originality by Maulana Abul Kalam Azad. So out of all these discussions, what I want to conclude, let me go back to the decision of Donuk versus Allied newspaper. In relation to literary work, this is an important statement. Include this part. In relation to literary work, copyright subsists in the particular form of language used. In deciding who is the author, we will have to see whose language is this. So going by this principle, it is still not clear as to whose language is there in the autobiography of Maulana Azad. So these are some of the observations in relation to authorship and ownership. Author is the person who creates the work, and a work of joint authorship would mean a work which is the result of contribution of two or more authors, where there is a common design collaboration. But the important thing is that the contributions must merge. If the contributions do not merge, it may be called as compilation. If the contributions are distinct, it may be called as compilation. It may not be called as a work of joint authorship. And I also said, more specific is your contribution towards originality of the work, better are your chances to be called as a joint author. Now, if we understand the meaning of the term author, I said we have to understand who is the owner. Section 17 defines ownership. It says author is the first owner of copyright, but at the same time it identifies many exceptions. Author is the first owner of copyright, but there are many exceptions. For example, if I make a work in the course of employment, as I mentioned in one of the classes, that if I prepare question paper for my university, I am only the author, university is the first owner. If I invent something, if I create some work in the course of employment, as part of my employment, I am only the author, university becomes the first owner. Similarly, if I create a work under contract of service, and I am sure you must be familiar with the difference between contract of service and contract for service. Contract of service is where what has to be done and how is it to be done, both is told by the master, whereas contract for service is a situation where what has to be done is to be told by the employer, by the hirer of the service, and how is it to be done is to be decided by me. Now, if I am doing it in the contract of service, whatever I create will be owned by my master. I am only the author, my master becomes the first owner. There is one important point called as a work created under a commissioned job arrangement. A commissioned job arrangement is one where I create the work on your behest for valuable consideration. If I am creating a work on your behest for valuable consideration, I am the author, you become the first owner. For example, if you hire my services, pay me and hire my services and ask me to make your portrait, I am the author of that portrait, you become the first owner of that portrait because it has been created under a commissioned job arrangement. You have a long list of exceptions. In case of government work, government is the owner. In case of work of public undertaking is the owner. There may be many engineers working to create a bridge, but the copyright will belong to government undertaking. So, these are some of the exceptions of the general rule that author becomes the first owner. I said there are three important things. One is any work created in the course of employment. Second is any work created under a contract of service. And third is any work which is created under a commissioned job arrangement. Keep in mind, under these three circumstances, these are most important exceptions. Under these three circumstances, the person who creates the work is only the author and the person hiring the services becomes the first owner. There is an important judgment of Supreme Court of 1977 called as Indian Performing Rights Society versus Eastern India Motion Pictures Association, where the producer hires a composer to create music on a commissioned job arrangement. This composer has already assigned all his present rights and future rights in favor of a copyright society called as IPRS. We will talk about copyright societies in detail later on. So, I have already assigned all my present rights and future rights to a copyright society, and I have asked the society to grant licenses in respect of those works. Now, I have already assigned all my present and future rights, and now I am working under a commissioned job arrangement for a producer to create composition for the songs or to write lyrics, whatever. Now, producer incorporates those lyrics and composition and he wants to release the cinema. IPRS, the society, files a case against the producer. This man, the lyricist, has already assigned all his future rights to me. So, the moment he writes a lyrics, it comes to IPRS. The assignment deed will operate and the work will come to IPRS. If you want to include it in cinema, you must take permission from IPRS. Whereas the producer is saying that we have already made payment to the lyricist, it's a commissioned job arrangement. So, the moment he creates the lyrics, I become the first owner. Because the lyricist never became the first owner, assignment deed will not operate. The case was decided in favor of producer. Yes, it's a commissioned job arrangement and the ownership will first of all vest in the producer and IPRS loses the case. This decision did not help the creators because what happened is now the lyrics belongs to the producer and the producer is free to include the lyrics in cinema. This is called synchronization right. He becomes the owner of synchronization right, including the lyrics in cinema. And he started using his control over all secondary uses of the lyrics or music. For example, if somebody wants to play that song, play that music in some reality show, then producer will give license, producer will give permission. So, authors are not getting remuneration or benefit because of any secondary use of the lyrics or the music. So, the case was decided in favor of producer, which goes against the interest of creators of the work, and therefore, in order to reverse the decision of IPRS, Indian Performing Rights Society versus Eastern India Motion Picture Association case, an amendment was done in 2012. A proviso was added in section 17, the last proviso, which says that in case the work is included in cinema, then proviso number B and C will not apply. Proviso B will say any work created in the course of employment. The other proviso will say any work created as commission job arrangement. These provisos will not apply. So, the last proviso is proviso to proviso number B and C, and exception to exception is rule. So, therefore, what is the meaning now? If I am working under a commission job arrangement and suppose the work is included in cinema, then exceptions will not apply, rule will apply, author becomes the first owner. Author becomes the first owner, assignment deed will operate, society will have the control, producer has to lose. So, if IPRS case is to be decided today, it will be decided in favor of IPRS and not in favor of producer. So that, why this amendment has been done? So that the authors are empowered. Authors get the benefit of secondary use of their works. So, this is about ownership. So, we understood who is an author, 2D, we understood what is work of joint authorship, 2Z. We also understood section 17, author is the first owner. There are various exceptions, but most important thing to be kept in mind is the judgment of IPRS versus Eastern India Motion Picture Association has been reversed in 2012 by adding a new proviso to section 17, which says that in case the work is included in cinema, proviso number B and proviso number C will not apply. That is one part of the discussion, ownership. The second part of the discussion is transfer of copyright. Owner can exploit the work himself. Owner can share it with others. There are many ways of administration of copyright. Broadly, we can divide administration into two parts. One is individual administration, where the author is exercising his rights himself, or author is either assigning or licensing his works to users himself. The second method of administration is collective administration, which is done by involving copyright societies. I assign all my rights to copyright society, and similarly there are many content creators who will assign their rights to IPRS, to copyright society, and society will collectively administer all these rights. We will talk about societies in some other lecture. In this session, we will restrict ourselves to the discussion on individual administration of copyright. And as I said, author can exploit his work himself, author can share his work with others for mutual benefit, and the way in which he can share his work with others, there are multiple ways. Section 18 talks about assignment of copyright, and section 30 will talk about license. I can assign my rights wholly or partially. I will assign some of the rights, or I may assign the entire copyright, all the rights. I can assign my present rights. I can assign rights in my future works. The only condition is that the assignment of future rights will be effective from the date when that future work comes into existence. Assignment can be made generally. Assignment can be made subject to conditions. Subject to conditions means condition as regards time. I assign you my rights for say 10 years or 20 years, I can impose a condition of time. I can impose a condition of number of rights. I assign only 2 rights to you, or I may assign 4 rights, all the rights. I can impose a condition of territory. I assign you the rights in the territory of Delhi, in the territory of UP. I may assign for the entire India. So, therefore, there are multiple conditions which I can impose. There is an important point written here if you see. No such assignment shall be applied to any medium or mode of exploitation of the work which did not exist or was not in commercial use at the time when the assignment was made. This was held by the Madras High Court in the case of Raj Video Vision versus K. Mohan Krishna. An assignment in relation to a work with respect to any medium or any mode of exploitation which did not exist on the date when assignment was made or was not in contemplation at all, such an assignment is not acceptable. What happened in this case? I assigned all my rights in my cinema in the year 1961 to somebody. I assigned all my rights in a cinema to somebody in the year 1961, and in the year 1981 I assigned video rights to a different person. Now the first assignee files a case that this amounts to breach of conditions. You have already assigned all your rights to me. How can you assign video rights to somebody else? Court says that in the year 1961 we did not have the video technology. So any assignment with respect to a mode which did not exist on that date will be of no use. Now this point was there in the case of Raj Video Vision versus K. Mohan Krishna. Now it finds place in the proviso to section 18. The second proviso to section 18 includes this principle which I just mentioned. No such assignment shall be applied to any medium or mode of exploitation of the work which did not exist or was not in commercial use at the time when the assignment was made. This came in section 18 by 2012 amendment. Prior to it, it was there in the form of the decision of Madras High Court in the case of Raj Video Vision versus K. Mohan Krishna. So therefore, section 18 talks about assignment. You can assign your rights wholly, you can assign your rights partially, you can assign your present rights, you can assign your future rights. Assignment of future right will become operative from the date when the future work comes into existence. Assignment can be made generally, it can be made subject to limitations, conditions. Those conditions may be of number of rights, the territory and the duration. So this is what you have in section 18. Section 19 talks about mode of assignment, how to enter into the assignment deed. And if you read section 9, you won't find any particular form prescribed here. There is no particular form of assignment prescribed in section 19. It only says that it must be in writing. It must be signed by the assigner and it must identify the work, specify the rights which are assigned, specify the duration for which the assignment will operate and specify the territorial extent of such assignment. So few points must be clearly there: what all rights are assigned, what is the duration for which it is assigned, and what is the territorial extent. Whether it is assigned only with respect to one state or two states or whole of India, that has to be clearly identified. So an assignment deed must be in writing, it must be signed by the assigner, it must identify the work, specify the rights, identify the duration and identify the territory. You have a case of Calcutta High Court, Jogendranath Sen. This case explains the nature of assignment deed. What happened in this case is I gave my manuscript to a publisher to publish and I gave it by way of assignment deed. That is, I assigned my rights, publication rights, to a publisher. That publisher did not publish it himself, he gave it to his son, a different publisher, to publish it. And I filed a case against the first publisher saying that you could not have transferred this right to a third party. Now, court decides the nature of this term assignment. Court says assignment means creation of interest in favor of assignee. It is similar to what we call as lease. You must have studied about lease in Transfer of Property Act, section 105. Lease means creation of interest and a lessee can sublease it. A lessee is as good as owner. Similarly, assignee becomes as good as owner of rights which are assigned, and therefore he can validly subassign the rights. So that is the nature of assignment deed. An assigner retains only those rights which have not been assigned, and an assignee becomes almost like an owner of the rights which have been assigned. Assignment leads to creation of interest in favor of assignee, and therefore an assignee can validly subassign. I said certain things have to be mentioned. I said rights, duration, territory. What if these are not mentioned? If period is not mentioned, it is deemed to be for 5 years. If territory is not mentioned, it is presumed to extend within India. So the entire country will become the territory. So you must clearly identify the territory or duration, otherwise these principles will work. And if the duration is not mentioned, it is presumed to be for 5 years. If territory is not mentioned, it is presumed to extend in whole of India. So 18 tells me what is assignment. 19 tells me what is the mode of doing that assignment. And then you have 19A, section 19A, which talks about a revocation of assignment. You can write a complaint as an assigner. You can write a complaint to the commercial court. Prior to the amendment of 2017, the responsibility was given to Copyright Board. In 2017, Copyright Board was merged with Intellectual Property Appellate Board. Later on, IPAB is scrapped and the jurisdiction of IPAB is given to commercial courts in relation to copyright. Under Patent Act, the jurisdiction of Intellectual Property Appellate Board has been given to the High Court. So a commercial court becomes the forum where you will have to write a complaint if you are the assigner. And after holding the inquiry, the commercial court will revoke the assignment if there are 2 points. If the assignee fails to make sufficient exercise of rights which have been assigned. I have assigned my rights to you and you are not using it. So first, if the assignee fails to make sufficient exercise of rights which have been assigned, and 2, that failure is not because of any reason attributable to the assigner. For example, I gave you my book to publish and I asked you to hold till the time I give you the subject index, and I am not giving you the subject index. You are unable to publish it. Why? Because of some act or some delay on my part. This does not become a case for revocation of assignment. So you are not exercising and the assigner is not responsible for that. That is the situation where the commercial court can order for revocation of assignment. So therefore, we have understood that assignment means creation of interest, and an assigner retains only those rights which have not been assigned. Assignee becomes owner of the rights which have been assigned. The next point is license. I said section 30 talks about license, and there is a fundamental difference between assignment and license. We will talk about that. But the first thing is, a license properly passes no interest. So assignment creates interest in favor of assignee. A license does not create any interest in favor of licensee. It only makes an action lawful which in the absence of that license would have been unlawful. So it is just a permission. If it is just a permission, it can be revoked at will. Whereas in case of assignment, you have creation of interest, and when there is a creation of interest, you cannot revoke the assignment on your will. So that's a very significant difference. Section 30 capital A, these provisions talk about form and content of license. The things are by and large same as those which we discussed in 19A. It has to be in writing, signed by the owner. It may be granted in relation to present rights. It may be granted in relation to future rights. The license of future rights will take effect when the work comes into existence. The license agreement must identify the work, the duration for which you are granting license, the rights with respect to which license is granted, the territorial extent within which the license will operate, the amount of royalty to be paid, if there is any possibility of revision of that license deed, an extension after the term is over, or any early termination, we want to terminate the license agreement before expiration of the duration of license, then such a provision as to how will you terminate must be there. These are the requirements of a valid license deed. You can license your present rights, future rights. It has to be in writing, signed by the owner of the work, identify the work, duration, rights, territorial extent, royalty, mention provision regarding revision, extension, termination. Because if you do not mention the rights, it is presumed to be for all the rights. It is presumed to be for all the rights. If you do not mention the rights, it is presumed to be for all the rights. There is a provision that if license is not exercised for 1 year, it is deemed to have lapsed. So, if you are a licensee, make sure that you exercise the rights which you get in license. If the period is not specified, I already mentioned in assignment, it is for 5 years, and if territory is not specified, it will extend to whole of India. License can be exclusive. Section 2J defines exclusive license. It can be exclusive, it can be non-exclusive. What do we mean by exclusive license? It is a permission given to one individual excluding all others. So, if I grant license to you, to one individual excluding all others, even the owner of the work is excluded from exercising those rights, such a license becomes exclusive license. On the other hand, if I grant it to more than one individual, or if I grant it to one individual at the same time I retain the right to administer it, then it does not become an exclusive license. So, you have the definition of exclusive license in 2(1)(j). It can again be classified. A license can be voluntary, a license can be compulsory. Voluntary license is not difficult to understand. I approach the owner, request for a license, we enter into an agreement, we negotiate the royalty, and license is issued. Second important thing is compulsory license. We will talk about it. It is a license granted by the owner under compulsion. He is not voluntarily willing to give license, but he is compelled in public interest to grant license. I said we will talk about difference between assignment and license. I have already mentioned assignee becomes the owner of rights which are assigned, whereas licensee only gets the permission to use certain rights. Usually lump sum payment is made in assignment, whereas in license royalties are paid or profit is paid. So, that is also an indication. If lump sum money is mentioned in the agreement, probably it is an assignment. If royalty is to be paid, probably it is license deed. In order to understand whether it is assignment or license, you will have to construct the document. You have to interpret the document so as to gather the intention of the parties. What parties intended at the time when they entered into the contract. Something similar to what we do in transfer of property to understand whether it is a lease deed or license deed. The landlord may always want to say that he is entering into a license deed. This license deed is entered on this date, the licensor will have these rights, the licensee will have these rights, the licensee will deposit the license fee on or before the 7th day of every calendar month. So, he is using the word license only to indicate that it is a license deed, and tomorrow if there is a dispute, he does not have any difficulty in removing you from the premises. But use of words are not conclusive. You may keep on using the word license, it may still be considered as assignment if it leads to creation of interest. Use of words is only indicative, it is not conclusive. So, what courts have to do? Courts have to construct, courts have to interpret the document to understand as to what parties intended at the time when they entered into the contract. As I said, use of words is indicative, it is not conclusive. You have to see as to what is the right which the recipient gets, what is the right which the transferee gets, and on the nature of rights which the transferee gets, you can decide whether it is assignment or license. If the contract contains some covenants which indicate that the transferor retains some rights. So, if I have some interference, some control over the rights which have been transferred, I retain some rights. These may indicate that it is partial assignment maybe or license. So, it ultimately depends on the extent of interest granted in favor of transferee to deal with the work. That will decide whether it is assignment or license. So, the bottom line is that the court has to interpret the document so as to understand the intention of the parties as to what they intended at the time when they entered into the contract. Words like assignment, license, lump sum payment, royalty payment, these are indicative, but these are not conclusive. Now, this is important. Let's come to the next point called as compulsory license. Compulsory license, as I said, Section 30 talks about voluntary license. I approached the owner, negotiated, owner gave me the permission to publish. Now, when I approach you, the owner is saying that no, I am not interested in publishing. In that case, what is the option left with me? I will have to request the authority to grant me compulsory license. And the authority will compel the owner to grant license to me. Grant license to me, why? Because the work is required in market, in public interest. Now, this is the chart which explains compulsory license. Compulsory license can be granted in relation to any work. Prior to amendment of 2012, Section 31 provided compulsory license in relation to Indian works. Now, the word Indian has been dropped and now it uses the word any work. So, compulsory license for any work here, compulsory license for non-Indian works here. Section 32 talks about compulsory license for non-Indian works. Let's first understand compulsory license for Indian works. There are two parts: compulsory license for published Indian works, which you have in Section 31, and compulsory license for unpublished Indian works, unpublished works, because now Indian goes. So, for published work you have Section 31, for unpublished work you have Section 31 capital A. Now, in published works, in case of published works, there are two clauses, 31(1)(a) and 31(1)(b). 31(1)(a) talks about a situation where the owner is approached with a request to grant license to republish his work, and owner refuses to grant permission to republish his work. Compulsory license can be issued. Whereas 31(1)(b) is a situation where the owner is requested to allow to broadcast his work, and the owner refuses to allow broadcasting. This is a situation where a radio station may approach some producer of sound recording with a request to allow him to broadcast the songs, and the producer of sound recording is refusing the permission. These two situations are covered in Section 31. You have 31(1)(a) where the owner refuses to allow you republication of his work, 31(1)(b) where the owner refuses to allow you to broadcast the phonogram, broadcast the work. This is about published works. The second thing is unpublished work. In 2012 amendment, some change has been done. It is no more limited to unpublished works. It also includes those published works which are now not available in market. The published works which are withheld from public, these are similar to unpublished works. So, it includes both unpublished works as well as those published works which are now withheld. In such a situation, a compulsory license can be issued by the authority if the author is either dead, the author is unknown, or author cannot be traced. These are the situations which are covered in Section 39 capital A. 39 capital A is for the purpose of compulsory license which is claimed in relation to either unpublished work or with respect to those published works which are withheld from public. The permission which you will get here is to translate the work. We will see to publish the work or translate the work. We will talk about 31A. So, there are two parts which I mentioned. One is section 31 where there are two clauses. Clause A is when the owner refuses to allow you to republish. Clause B, when the owner refuses to allow you to broadcast his phonogram, you can claim compulsory license. 31 capital A is a situation where either the work is unpublished or even if it is published, it is now not available in market and author is either dead or unknown or cannot be traced. Then how will you claim license? How will you publish that work? And third is section 32, which is about non-Indian works. You can claim compulsory license to publish translation of non-Indian literary and dramatic works. You can claim compulsory license to publish translation of non-Indian literary and dramatic works. The purposes are mentioned. You can do it only for teaching purpose or scholarship purpose or research purpose. And there are conditions. You can publish translation in any language in general use in India, or you can publish translation in a language that is not in general use in developed countries. So, you cannot publish translation in French, Japanese, Korean. You can publish translation in Nepalese or Singli maybe, or Arabi. So, they are not giving you much. They are allowing you to publish translation of non-Indian works in a language which is in general use in India and in a language which is not in general use in developed countries. In this case, you can publish translation after expiry of 3 years of publication of that non-Indian work. And in this case, you can publish after expiry of 1 year. So, this is the chart which explains the scheme of compulsory license under Indian law. Let me tell you, compulsory license provision is a matter of public interest. In the name of public interest, the owner is compelled to grant license to a third party. But keep in mind, this license is not free. The licensee will have to pay some remuneration to the owner, but the remuneration will be decided by the competent authority. In our case, the competent authority is commercial court. So, in all the cases on your application, the commercial court has to decide the equitable remuneration which is to be paid to the owner. In Indian copyright, there are many provisions which may be called as public interest provisions. The first is the duration. I have already mentioned that copyright is not unlimited right. It is limited over time. So, therefore, by the fact that the rights will come to public domain after a certain period of time would mean that it is a public interest statement. Second, compulsory license. Compulsory license mechanism is a public interest provision. The owner of copyright cannot create scarcity of the work. The owner of the copyright cannot abuse his monopoly, and if he abuses, then he will be compelled to give license to a third party. And the third set of public interest provision is there in section 52. We will talk about it later on. So, coming back to the chart, this is the scheme. You have compulsory license for published works, you have compulsory license for unpublished works or even those works which are published but are withheld, and you have a provision on compulsory license for non-Indian works. Now, let us quickly understand these sections one by one. Section 31, 1A, as I said, is a situation where you approach the owner refuses to allow republication of his work. You see, you are offering certain reasonable terms and conditions to the owner of copyright. I will give you this much money and publish these many copies. If the owner is not agreeing on those reasonable terms, it is as bad as a refusal to agree on your request. So you approach the owner, he refuses to allow you to republish his work, as a result of which the work is withheld from public, it is not available to public. Then in that case you can write a complaint to the commercial court, and if the commercial court is satisfied means the commercial court will have to conduct an inquiry. If the commercial court is satisfied, it will direct the registrar to grant license. This is what you have in section 31(1)(a). Coming to 31(1)(b), the steps are same except few changes. You approach the owner refused to allow you to broadcast the work. Point number 3 is not there. As a result of refusal to broadcast, the work may or may not be withheld. This is important. 31(1)(a) is a situation when the work is withheld. 31(1)(b), where even if the work is not withheld, you can write a complaint to the commercial court, and the commercial court may grant license. 31(1)(b) is a kind of exception to 31(1)(a). The general rule in case of compulsory license is, I approach the owner, owner refuses to grant me license to publish, or as a result of which the work is withheld, then I am claiming compulsory license. What is happening in 31(1)(b)? A special case of broadcasting is carved out from general rule. In case of broadcasting, I approach the owner refused to allow me to broadcast. The work may or may not be withheld. Still I can claim compulsory license. So this is one significant point of difference. Work may or may not be withheld, which you have in 31(1)(b), whereas the work must be withheld, it is clearly mentioned in 31(1)(a), and therefore I said 31(1)(b) is in a kind of proviso to 31(1)(b). I said compulsory license is not for free. You will have to make payment of compensation, equitable remuneration to the owner. Who will decide? The commercial court will decide. 31 subsection 2, which is now omitted, provided that in relation to 31(1)(a), only one person will be granted compulsory license. But in case of 31(1)(b), that is to broadcast the work, more than one individual may be granted compulsory license. But keep in mind that compulsory license should be a matter of last resort. Many people must not be granted compulsory license. You can refer to the case of Phonographic Performance Limited versus Music Broadcast Private Limited, 2004, Bombay High Court, to understand the meaning of now omitted section 31(2), because the part which was contained in 31(2) is now there in 31(1) itself. 31(a) talks about compulsory license for unpublished works, or even those works which are published but now withheld. If you want to publish that work, you must publish your proposal in a national newspaper, or if you want to publish the translation of that work, that you must publish the proposal in one of the regional newspapers. The idea is anybody who wants to object may come forward. The commercial court, after holding the inquiry, will direct the registrar to grant compulsory license, because the situation is author is dead, or author is unknown, or author is traceless. So therefore there is nobody to receive the royalty. In that case, commercial court may require the registrar to ask the licensee to deposit money in one of the identified bank accounts, so that in future if somebody claims, the money can be given to that person. The last one is section 32. I have already mentioned, you get the permission to publish translation of non-Indian work in language which is in general use in India, or in a language which is not in general use in developed countries. There are few procedural requirements. For example, applicant has requested the owner, or he is unable to find the owner is traceless. In that case, what will happen? You will send the request to the publisher by registered airmail. The commercial court has to be satisfied that the applicant is competent to publish the translation. Hearing must be given to the owner wherever practicable. And in case of translation of non-Indian works, the translated version must contain the name of the author and the title of edition which is translated. These are just the safeguards. So what we discussed In the present session, we discuss the concept of authorship, ownership, assignment and license. We discussed the very important concept of compulsory license, where we understood that compulsory license with respect to any work is there in 31 and 31 capital A. With respect to non-Indian works, it is there in section 32. There is a provision for termination of compulsory license also. If the owner himself wants to bring translation, published translation at a competitive price, that becomes a basis for the commercial code to terminate the compulsory license. We also discussed the concept of authorship, ownership. I briefly mentioned that the ownership of AI generated works is still not settled. I said compulsory license is a public interest provision. Another important public interest provision is to be found in section 52. We will talk about section 52 later on. The next session shall be on infringement of copyright. We have understood subject matter, meaning of copyright, authorship, ownership, transfer of copyright. Next session will be on infringement of copyright. That's all for this session. Thank you very much for joining. Thank you.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said but also in what remains unsaid. Today I'll be reading one of the shortest instances of a short story that I have ever encountered, and indeed the very charm of this particular story that I'm going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I'll be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samarra. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samarra and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samarra to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samarra. See you in the next episode of Literary Snippet.